Yes.
May I please, Your Lordship? I beg to mention item number 10. Lordship.
You are for?
Appellant, Your Lordship.
For the state, no objection, my lord.
2 weeks, Your Lordship. 2 weeks time, Your Lordship.
On premiere by the appellant. This is matter to 2 weeks.
Obliged, Your Lordship.
Excuse me.
Lordship, I beg to make a mention item number 8 of the hearing list. This matter may be taken up after 2 weeks, Your Lordship.
I am also for respondent.
2 weeks. 8.
What is this matter about?
Well, this is a teacher's matter, my lord. It's the government was asked to produce some records. So only for that was pending. my
Just
lord.
terminated, again re-terminated teacher. That is the case. There was a departmental inquiry was conducted.
Who is appearing for the petitioner?
Mr.
S.R. Lindo.
SR,
He's not here.
he is not here.
I'll inform him because morning I could not get him, Your Lordship.
We should have got his consent.
But I was looking, I thought that he'll be in the court premises, but
Let the matter be called up.
yes, Your Lordship. Highly obliged, Your Lordship.
Please, Lordship. I beg to make a mention for item 2, Your Lordship. I pray that the matter may come tomorrow, Your Lordship. We have filed the miss case for the extensions of bail, Your Lordship. It's listed tomorrow, Your Lordship, the miss case.
No objection. On premiere by the appellant, this is matter tomorrow.
Similarly, pray for item 3 and 4, Your Lordship. Pray the matter may come after 2 weeks, Lordship.
3 and 4. No objection, Lordship. On premiere by the petitioner, this is matter after 2 weeks.
Really obliged.
Please, Your Lordship, I beg to mention item number 12. This matter will be come up after 2 weeks, Your Lordship.
What is this matter about?
Poxo matter.
Is it so matter and rushing?
Poxo matter, my lord.
Also matter about what? Is it a... It's a petition under 482 or what is
42, Your Lordship.
Quashing.
on premiere by the petitioner? This is matter to 3 weeks.
Daily cost list, item number 1.
The last occasion, my lord has given us to prepare the paper book. My lord, my colleague has checked the record, and the records are incomplete, received from the trial court. For instance, my lord, the record containing the exhibits and paper books are not here, my lord. So we are unable to proceed for preparing the paper book. So if lordship direct the trial court to send those relevant records, my lord, that will enable us.
What is missing, you said?
My lord, the exhibits and the paper books, the paper marks, is essential evidence in the trial court. So this is not what they send is the order sheets and the daily attendance of the lawyers only. So evidence are not there.
Mr. Savisul and Senior Counsel appearing for the appellant has submitted that on being directed by this court to prepare the paper book, the lower court records since produced before this court was produced. However, it is found that some of the relevant portion of the records is missing, are missing. For instance, copies of the deposition and deposition.
Copies of the exhibits and paper marks.
Copies of the exhibits and paper mark. on prohibit the trial court is directed to classify whatever is required to be produced before this court as far as the second records are concerned, and to produce the same before this court on the next date fixed. This is matter to 2 weeks.
Obliged, Your Lordship.
Item number 5.
Your Lordship, this is a land competition in Dalu. Seeking direction to the District Collector of West Garo Hill, Your Lordship. This is pending for long, and if permitted, I would like to complete my submission.
Lordship, Mr. KP is the conducting counsel in this matter, Lordship. So he has not come.
But that would be very irresponsible of him not to come.
Let it be after the board, at the end of the board, Lordship.
Okay, Your Lordship.
Item number 6.
Please, Your Lordship. Your Lordship, in this case, Your Lordship, there has been a negotiating, Your Lordship, but till now it's not yet finalized. So I'm just asking for 2 weeks time, Your Lordship.
What is this matter about?
This is compensation, Your Lordship.
Compensation?
Yes, sir.
Compensation on what account?
The land, Your Lordship.
Your Lordship, they claim that the government has taken their land and they're claiming for compensation, whereas the government has already given them appointment, Your Lordship, to one of the relatives.
Oh, so now
Negotiation is going on, Your Lordship. So
I have no instruction.
that was my instruction, Your Lordship.
the counsel for the petitioner has submitted that there are that the relevant parties are in negotiation for an amicable settlement to this matter, for which some more time is required for the outcome of this same to be produced, to be reported to this court. Ms. Ailwa Leonard G, on the other hand, has submitted that she has no instruction as far as such negotiations are concerned. Be that as it may, on pre-paid by parties, this is matter to 2 weeks.
All right.
Obliged, Lordship.
Item number 7.
May it please your Lordship. Lordship, I'm praying if this matter may be listed at the end of the board.
Lordship, actually, I just been informed by the petitioner that they are not filing their counter affidavit anymore, and they want to proceed ahead for the hearing. So,
Petitioner?
yes, Your Lordship, and the conducting counsel for respondent 1 and 2 is not available. So, Lordship, may kindly list for hearing on the next day.
Oh, she is the petitioner.
Yes, Your Honor. But
So she is to say whether the petitioner is to file the rejoinder. Rejoinder, is it?
Lordship, but Lordship, this matter has been posted for hearing. In the meantime, we had sought for time to file our rejoinder to the counter affidavit. But we're no longer, we've received instructions, Lordship, that we will no longer be filing our rejoinder. We'll go ahead with the hearing, Lordship.
And counsel for the petitioner has submitted that the rejoinder to the counter affidavit filed by the respondent 1 and 2 would not be necessary to be filed, and as such has prayed that this matter may be finally heard. Learned counsel, Mr. Learned counsel for the respondent 1 and 2 has, however, sought for accommodation as far as hearing of this matter for the day hearing of this matter is concerned. On pre-meet, matter is adjourned. This is after 3 weeks.
Highly obliged.
Obliged, Lordship.
Item number 8.
Petitioners absent.
None appears for the petitioner on pre-meet by learned counsel for the respondents. Matter is adjourned. This is after 3 weeks.
Item number 9.
Yes. Please stop.
My lord, Mr. Paul is on his legs, my lord. He is leading in this case, my lord. So I'm praying if this matter can be taken up by end of the board, my lord.
End of the board.
Item number 11.
Maybe, please, Your Lordship. Your Lordship, this is a matter that the CMJ University, that MA in Philosophy, she obtained a degree in 2011. However, about the notification date or date of hearing, she was not known. Then when she applied for provincial election in Assam for a school, secondary, she is the principal. At that time, on verification, they found that to clarify her degree of MA. Then she approached for the Guwahati High Court. In fact, she should have approached the High Court of Meghalaya. Guwahati High Court, though they directed her to give the representation, since Meghalaya was not a party. So accordingly, she gave the representation, and after the representation, what happened? In a very slipshod manner, they have given the reply. If Your Lordship is pleased to see page 85. Page 85, Your Lordship.
Yes.
That's serial number 7. The hearing process was completed on 1st April 2014.
Yes,
Your
where is the
Lordship.
type copy of this?
Of course, this is the copy I have, I think, Your Lordship. Only that one sentence, Your Lordship. The hearing process was completed on 1st April 2014. So that was not known to her. Therefore, the result.
Yes, just a moment. You're reading page 85.
85, Your Lordship.
Hearing process started on?
The hearing process was completed on 1st April 2014. Your Lordship. Means they have given a chance to the candidate, those who are getting the degree, to come and appear before the government. But that was not known to her. So that means the reason neither my representation has been disposed of on the ground that I have approached belated, therefore they rejected. Then serial number 8, out of 9,177 representation, 1658 candidate, 1,650 appeared before the hearing committee, and 7,519 were absent. Your Lordship. The outcome of the hearing was intimated individually by post to all the 1,658 candidates. As per record, you have not submitted a representation regarding validation of degrees and have not appeared in person for the above mentioned hearing. So this is the ground that they have given me my answer on my representation. So my respectful submission that, because I am a degree holder in the MA holder in philosophy, let my representation be reconsidered only. Only that much I want at this stage. Because they didn't give me the hearing. Since I have submitted B letter, therefore they have signed it back.
How was the process for the hearing process notified, Mr. Sengupta?
That
paragraph 1.
Yes.
Notice was issued to the government on 14 February 2014 through national and local newspapers and government website.
Where is it? Okay.
Para 1.
Because here it says only notified on the government website. Information to the candidates or to the students of CMJ.
Para 1.
Yes, that's it, page 85. Oh, this is page 84. Here.
No, 84. That will be 84. Page 84. If I permit to follow here on the.
Yes. It's here, but it's marked as 84.
No.
It was earlier marked as 85 crossed, and then 84 was.
84, I think.
That's I think the same one that you have.
Same one. So this will be page 84, my lord. Yes. Para 1, my lord.
Yes.
Notice was issued by the government on 14 February 2014 through national, local newspapers and government website to the students of CMG University who have submitted their representation regarding validation of the degrees to appear in person for hearing along with the relevant supporting documents from so-and-so onwards at JN Sports Complex Polo. So, my lord, at para 3, there was a committee, my lord, hearing committee. A committee was formed of 3 members.
But
now the petitioner herein did not take part in that process, my lord, and the order of the Supreme Court was way back in 2013. That is more than 10 years has lapsed since. Unfortunately for the petitioner, she has missed her bus. She has missed the bus. So there's no question of reopening the entire thing again, my lord. Because as a degree holder, they were very much aware of what was happening. It's not that something that has happened behind the back or suddenly. Since 2010, CMG University was having problems.
there's a disputed issue of facts involved. In as much as here it is said that notice was issued by the government through
Yes.
national, local newspapers and government website.
Yes.
Now, how are we to verify or ascertain that the petitioner, was aware of this proceedings, or that she was not aware? Her claim is that she was not aware of these.
My lord, if we are to go by that, my lord, every second student will come before your lordships and make the same claim. In fact, my lord, I have prepared a list of my lord, judgments where various high courts have rejected, my lord, over the years. May I hand over, my lord? Because various students have gone to various high courts, my lord, and they've all been rejected, my lord.
I think that is the only issue to be decided.
Because
whether you are, bona fide, you have missed the set notification or deliberately.
Yes, my lord. That discretion is with your lordship. I will not.
We'll have to go by.
Yes, my lord.
We'll have to go by. See what are the norms required in this regard.
Yes, my lord.
And whether when was the information made known to you, Mr. Mata? When did you came to know of this?
I came to know, your lordship, when it is in 2000, your lordship. When the provision that one resulted, that is at page 36, your lordship, annexure 3. When we have applied for provincialization,
okay,
that time we came to know.
With my lord, kindly have page 140. 140 would be 139 or 140. The High Court, Guwahati High Court order, my lord. 140, my lord. This is what page?
Where's 140? Of the petition?
Oh, sorry, my lord.
No, that's
72, my lord. So page nation is 74.
72.
72. Mine shows 74 and 140. So, my lord, this is the Guwahati High Court order, my lord, in a writ petition filed by the petitioner before the Honorable Guwahati High Court. And, my lord, next page, my lord, will see the order date, 1st of April 2022. So, the issue which was before the Guwahati High Court was different, but ultimately it culminated to the degree of the petitioner. And the operative part, Your Lordship will find at page para 8 onwards, my lord. Para 8 onwards. That would be page 77. 77? Yes.
Yes.
If I may read, my lord. Lord, the court finds the force in the submission made by the Learned Standing Council for the Secondary Education Department. Therefore, notwithstanding that the state of Meghalaya is not a party in the writ petition, but as the Supreme Court of India had made an observation that students whose admission and degrees were declared illegal may also make representation to the state government and seek an opportunity of hearing from it. The court is inclined to close this writ petition, however, by granting liberty to the petitioner herein to submit a representation before the appropriate authority in the government of Meghalaya for taking an appropriate decision as the validity of her degree of MA in philosophy, which was awarded to the petitioner in the year 2011. Accordingly, the court is inclined to grant liberty to the petitioner to submit her representation before the competent authority of the government of Meghalaya along with a certified copy of this order. Having noted the projection made by the Learned Senior Counsel for the petitioner that the petitioner was initially appointed as principal of so-and-so, the court would expect the competent authority of State of Meghalaya to pass an appropriate order as early as possible, preferably within an outer period of 2 months from the date of receipt of representation along with the copy of this order. And para 11, my lord. It is also made clear if the petitioner is aggrieved by any order that may be passed by the government of Meghalaya or non-consideration of the representation within the time limit, time allowed, it will be open for the petitioner to move the High Court of Meghalaya for seeking appropriate remedy as the petitioner may be so advised. Thereafter, my lord, at the next page, the petitioner has made a representation. And the page 84, my lord, that my learned senior had pointed out, that is the reply by us to the representation. So we have dealt with the representation, saying that you have come in a belated stage. There's nothing much that we can do now. Since the other students also, they have been heard previously, and despite notice, you have not appeared. So, my lord, now it's up to your lordship, my lords. Now, if your lordships, because we have dealt with the representation, it's not that we have not dealt.
So now we are only on the manner in which the representation was dealt with.
Yes, my lord.
Whether it was right or wrong, or
yes,
proper or improper.
Yes.
I was not even heard, Your Lordship. I was not even heard. That's the problem. Because why? At para 19 of my writ petition, Your Lordship will see. I have put a statement there. Para 19, Your Lordship, that page 15 of my writ petition, Your Lordship.
What you mean to say is that on being directed by the Guwahati High Court,
yes,
you had filed a representation.
Representation.
You were not heard.
I was not heard.
Subsequently, the impugn order was passed.
Yes, impugn order was passed without hearing me, because even the CMJ University, Your Lordship will see, they didn't deny it. This is my submission, Your Honor. Lordship, that para 19 I have said that the petitioner begs to state that on 4/8/2021, the registered CMJ University Meghalaya had replied to the letter dated 28/7/2021 by stating that the MA degree awarded to the petitioner is correct and genuine, and the same has been issued by the CMJ University under Section 22 of the UGC Act 1956. Moreover, certificate dated 8/8/2016 was also attached by the registrar to the letter dated. So, CMJ didn't deny my degree. It said that they didn't.
I think we are not on that.
Yes, we are not on that. Therefore, I want my year to be considered.
It is only on the point as to whether you are eligible to be heard.
Yes.
Or not.
Yes.
Whether you have been heard or you have not been heard.
Yes.
Have you made any amendment in your counter with regard to that?
Yes, Lord, we have filed a very extensive counter.
That is all those judgment of Supreme Court is there, and another.
We have indicated the entire.
We are not talking about judgment. Now we are talking about the facts situation.
Yes. We have.
He says that, or rather, she says that she has not been heard.
Yes, Lord.
And what do you say? Are there any records, any proceedings to show that she was heard? Is it required for her to appear personally?
No, my lord. No, my lord.
Because
The
I have to
direction-
substantiate. Even the CMJ University has to substantiate that. How my degree?
What has happened
CM,
is,
CMJ is a performer respondent here.
just I can only make a submission, you can't stop me. My learner friend was there yesterday. The matter of invalidation on a larger conspectus, where the university also goes and comes before this honorable court, says that we were also not even called. The record on which they purportedly relied upon was never there with them. It was lying seized with the police officials. The writ petition notice is issued. The matter was listed.
No, my lord.
Just
No, my
one
lord.
second. Please don't say no. In between, either you allow me to argue the matter or you only argue.
Just
Well, that matter is listed yesterday. My learner friend was also there. Writ petition 349 of 2023. Notice has been issued in that matter, filed by the filed by the CMJ University. My learner friend was appearing.
My lord,
Item
my
number
lord,
1.
may I interject? May I interject?
Is it regard with the in connection with this particular subject matter?
No. Of course. It percolates to this very, because what my learner friend, my petitioner, petitioner's case is invalidation of degree.
Mr. Singh, what we are concerned here is a process that is going on or that has been completed, wherein the students or whoever have got degrees from CMJ were allowed to make representation before the government. To that extent, some have appeared, some have not. So now, in this particular case, the petitioner says that she is not aware of the notice.
Even we are not on.
I know whether
My rate is
whether you're required to be
precisely, but my rate is
whether you're required to be present in the proceedings, that
because
is
the
not-
record was with me. The entire record of validation of degrees, what has happened was
My lord, may I interject? May I interject, my lord?
That,
May I
Mr.
interject?
Singh, I don't think. I think you are going.
Yes, my lord,
off
beyond.
in the invalidation of degrees
We are not.
is the direct question
We are not.
pending in writ petition 349 of 2023.
We are not on that. We are not on that.
This writ petition
As
is
to
also an invalidation.
Mr. Singh, just hear
Then,
me.
my lord, list this matter along with that.
We are
matter.
not. We are not on that. We are not on whether the contents of the proceedings would include your documents or your relevant papers, whatever the case may be. We are only on the process now.
My lord, learned friend is going in that direction, my lord. Let this matter be listed along with that matter. my lord.
Why would it be?
Have prayer 2 of my learner friend's writ petition, page 26. They want validation of this very degree.
I'm not on that. The query of this court is whether the petitioner has been hurt or not.
Very good.
Simple
But
as
I
that.
have nothing to
So
say
that
because
is
has to be answered by the state only.
that's why. Why are you in your
Exactly,
interjecting?
my lord.
No, I'm not.
Exactly,
I'm a
my lord.
party. I'm a
You are a
respondent number
party.
3
I will
and
hear
4.
you.
I need to respond.
I will hear you as
Very good. Then here's
as and when it's
my
required.
whatever time.
So, my lord, representation was made. We replied to the representation. That process was completed in 2014. There's nothing more that we can do. That is what our reply has been, my lord. So, my lord, now it is for your lordship, my lord.
Mr. Nongri,
Yes, my lord.
what would be pertinent is the fact that whether she was
not.
she had
In
appeared,
person, she was not given an opportunity.
because what happened is now the petitioner cannot say that she is not aware of the proceedings, of the hearing proceeding, because the petition was filed before the Guwahati High Court,
Yes, my lord.
which has allowed her to make a representation.
Only.
That would have been this would have been a special case.
Yes, my lord.
So what happened is now she has filed her representation, and in the process you say that her representation was was taken into account and the order was passed. But the only point here is this, that she has asserted that she was not heard. If that is the case, then the whole procedure of
Exactly, my lord.
of hearing would be
Exactly, my
redundant.
That is what I'm indicating. The only liberty granted by the Honorable Guwahati High Court is to make a representation and for us to consider.
Yes.
There was no direction to give a personal hearing, my lord. Now they are now the petitioners before your lordship with that grievance that
See,
now it
when,
is up
when,
to
a,
your
when,
lordship.
when a representation is filed,
Yes,
what would it entail? It would naturally entail consideration,
consideration.
for which if personal appearance is required, then you have to do it.
Yes, my lord.
Only there's a limited prayer. Therefore, I said to reconsider and give us a hearing.
Because as per us, my lord, as per the government,
You do one thing, sir. You
Yes.
produce the records of the proceedings.
I'll do that. From the records that I have, personal hearing was not granted.
That's it, my
Personal
case.
granted
So
was
then let
personal-
them hear me. That's all.
And
So now
in
you're
terms of,
so now you're admitting that personal hearing was not accorded
it
to
is
her.
clear from the record, my lord. It is clear from the record. What I'm saying is, this entire exercise under the directions of the Honorable Supreme Court for the students to make a representation, that entire the entire exercise was completed in 2014. Now, Guwahati High Court in 2022 has granted the petitioner an opportunity to make a representation. There was no direction for personal appearance, my lord, for personal hearing. Therefore, we didn't call the petitioner. Now, they are before your lordship, my lord. Now, it is your lordship's discretion. If your lordship feels that we should give them, my lord may.
I want only that limited prayer.
And I think now the stand of Mr. Singh would be that even if you take up her representation, you would require the records with you, which, as Mr. Singh has said, is not in your possession.
My lord, what Mr. Singh is trying to do, for that I have to reopen the entire case. If your lordships recollect in that DB matter which your lordships had heard, the appeal filed by the state, the governor had invalidated all the degrees, my lord. Therefore, the Supreme Court had granted an opportunity to the students as on sympathetic grounds that you kindly approach the government if the government can help you in some way. Those degrees are already invalid, my lord. There's nothing, the records will not help, my lord. It is just a sympathetic hearing, my lord, for the government to make a decision. That's all, my lord. There's no records required, my lord. Those degrees are invalid, they're invalid, my lord.
Where is the copy of your representation, Mr. Manta?
Yes. At page 79, your lordship.
So this is your representation.
Yes. 18/4/2022, page 79, your lordship, annex 7.
And what have you annexed with this representation?
I've stated about the High Court order, then
Relevant documents enclosed herewith is the last paragraph at page 83. There is no list.
Last para.
At page 83, the bottom is the relevant documents enclosed.
Oh yes, relevant documents.
Enclosed the-
So where is?
The list is not there.
no list is not there.
So what do we understand from this? What are the relevant documents for which they have to verify or validate?
The records will be with the CMJ University because even the government cannot invalidate my degree, your lordship.
petitioner
It
wants
is
to-
the CMJ University who can come
If
and
the
say that.
petitioner wants to involve CMJ University, my lord, let us have a proper hearing on this
It is
entire.
the respondent 3 and 4 are the
We have
CMJ
to go
University.
through all the orders, my lord, right from 2010. We can't involve. Representation is made by a student, my lord. We will consider that, my lord. We will give her a hearing. There's no question of calling them for a hearing, my lord.
So yeah, let them give the
We
hearing.
are not saying that.
We don't need the records.
That is the onus is on you.
Yes.
The onus is on you. Whom you call, you have to make a call as to what is required with that, so as to firstly, to give a fair hearing to all involved. That would.
Petitioner, my lord. Others have been granted, my lord. They have appeared.
And we're talking about petitioner here. We're talking about a fair process here.
Yes, my lord. Similar treatment that was given to other students, my lord. Those 9,100 and something, my lord. Same treatment will be given to the petitioner.
Yes, that
Yes, my lord.
that would be upon you.
Yes.
So I think to this extent we'll allow the.
Just to allow me to.
It'll be a time-bound direction
Yes.
that you have to appear personally before the concerned authority.
Yes.
Within a certain day.
As you lordship.
Or on a specific day, as you suggest.
As you lordship.
Only problem is, my lord, this representation is made to the Honorable Minister.
No.
Minister.
Mrs. So-and-so, wife of so-and-so, they say. Wife of so-and-so.
Why are you making a representation directly to the minister?
Right to the respond number 2, it should happen. Anyway, I can give resubmit under it.
It should be to the,
To the direct to the office.
the
office
department concerned.
I'll to the respond number 2. I'll give.
And my lord,
For all we know, but of course.
Secretary, let it be Secretary, Education Department, my lord.
As your lordship.
Because Deputy Secretary, respondent number 2 is too low a rank. Secretary will be the.
So, Mr. Singh, as far as you're concerned,
I'm
let them
not concerned with anything.
let them
I
deal.
just wanted to just put a point.
Let them deal with the matter.
Yes.
Let them deal with the matter. If the outcome is not satisfying to you, then you can take your own course of action.
I am there already. My matter notice is already issued. He is already there.
That is a different thing.
You argue in
I
those
just
matters,
wanted-
not in this
no,
matter.
I don't want. If I am a respondent, I need to respond, say something. But you should have told this honorable court. I am saying that the government should have disclosed this factum that the university has also filed a writ petition.
No, I don't require.
If
I don't
No,
require.
that's precisely why
I
I'm
don't
here.
require.
That is, I think, not as far as this matter is concerned.
Yes, ma'am. I don't require.
Heard, Mr. SP. SP Manta, Secretary, Education, Senior Counsel appearing for the petitioner. Who has submitted that. The petitioner. What is her present status now of position?
She's a principal.
She's still a principal now.
Principal, since principal.
Is the principal of Haji Amsar Ali Mukhtar Girls Senior Secondary School, Morigaon, Assam. The petitioner was recommended for provincialization of these said school. Just correct me if I'm wrong. For which a state level scrutiny committee was constituted to verify the recommendation made by the district level scrutiny committee, the name of the petitioner being one of such recommendee. However, in course of such proceedings, a remark was made as to the authenticity of the MA degree obtained by the petitioner from the CMJ University, which has to be clarified. In due course, the state of Assam in due course, the authorities concerned had uploaded a list of eligible and qualified education institutions and the staff serving in those institutions for the purpose of provincialization of their services. The petitioner, on perusal of such list, has found out that her name was not included in such list. Next, on being aggrieved by the same, the petitioner has filed a writ petition being WPC number 3260/2021 before the Honorable Guwahati High Court, and the court and the Honorable High Court by order dated 15/7/2021. Where is that order, Mr.? Where is that order, Mr. Munta? High Court's order?
Court order, your lordships will find at page 72 onwards, Lord.
72.
Relevant portion at page 77. Starts at 72.
There are 877.
Para 8 to para 11.
No, this would be WPC number
1352.
1352. Kunung to count the last line. Yeah, by order dated 1/4/2022 has allowed the petitioner to file a representation for the competent authority of the government of Meghalaya. The petitioner, in compliance with such order, has accordingly filed a representation dated 18/4/2022 before the Honorable Education Minister, Government of Meghalaya. It appears that the said representation was taken on board and the same was disposed of and communicated, and such disposal was communicated to the petitioner by communication dated 31 number FDN, those I'm going number, and it's 18 dated 31/5/2022, whereby it was she was intimated that her representation was not considered since the period for preferring such representation has already elapsed. Being aggrieved by such decision, the petitioner is before this court. With a prayer for direction to the with a prayer inter alia to quash and set aside the said order dated 31/5/2022. The learned senior counsel for the petitioner has only a one-point submission before this court, and that is because of the fact that the petitioner was not allowed, or rather was not accorded the opportunity to be heard personally when her representation was considered by the concerned authority. Therefore, the principle of natural justice was violated as far as she is concerned, and for which at this juncture prayer is made for a direction by this court to the respondent, to the relevant respondent, to reconsider the said representation by according her an opportunity to be heard in person. Mr. Clement Nongri, learned counsel for the respondent number 2. You are for the state?
Yes, ma'am. 1 and 2.
For the state respondent has submitted that firstly, the petitioner has approached the concerned authority very late in the day. However, in spite of that, the representation dated 18/4/2022 was duly considered, and being found devoid of merit, the same was disposed of, and such decision was duly communicated to the petitioner by the letter dated 31/5/2022. However, even at this point of time, the learned counsel has submitted that if directed, the petitioner will be allowed to file a representation, and the same will be considered by affording her an opportunity to be heard. Without considering any other points or issues involved in this matter, including this stand of the respondent 3 and 4, if at all, on this short premise, the matter is hereby disposed of by directing It is hereby directed that the petitioner will file fresh representation before the appropriate authority within 2 days. So within the 14th.
It's 1 week. 1 week.
2 weeks time, I think, Your Lordship, yes.
We'll give a specific date so that it will not be confusing. Within the 21st of February.
21st.
The authorities concerned is to take up the matter and dispose it off within 7th of March. I'll give you 2 weeks time.
My lord.
Representation will be addressed to secretary as per
secretary.
I said appropriate authority, so it's up to you whom you address the matter to.
But not the minister.
No.
It should not be. Of course, this court would not make comment. That would be.
But Your Lordship, as per the Supreme Court Watch order, seek an opportunity of hearing and to consider sympathetically that what.
No, that would be for them.
That judgment is
Whether,
already in
whether they are sympathetic or not, what
Yes.
can we see?
That judgment is
That judgment will be taken into account because you will be heard personally.
deeply organized, Lordship, deeply organized.
Accordingly, matter is disposed of with such direction.
Item number 5.
Lordship, you are calling Mr. K.P. Bhattacharjee.
Yes, please start.
Grateful, Your Lordship. This is a land taken by BSF for establishment of border outpost, Your Lordship, at Dalu. The petitioner has given willingness certificate long back for establishment of the border security outpost. Can see Annexure 1, page 11 of the petition, Your Lordship. And if we go to the to Annexure 2, serial number 11.
What does Annexure 1 says?
Willingness. May I read, Your Lordship?
Yes, please.
It is certified that I, Sri Nukme Di Sangma, Nokma, Village Maguapara Akang, number 2, 1537, Post Chandobai, Tehsil Tura, District West Garo Hill, Meghalaya State, is agreed with all my concern to sell a part of land, approximately 5 acres, to 35 battalion BSF under Village Chandboy near BP number 1112-5, 200 meter behind from international border. The same land is in possession of BSF since 1980, area 23 Bika, 4 Kata, 12 Lisa. He is a permanent concrete structure, BOP, namely Chandobai. I also declare that I will never make any claim that part of land in future. I also agree that the cost of the land will be provided by the state government at government rate. I signed in the agreement in the presence of the following witnesses: Sukur Mar Sangma, son of the Bising Courts, and this Nukme, owner of the land, Your Lordship. Then we have gone for RTI because it was so too long. We have gone through RTI from the BSF. It can be seen from RTI Annexure 2, Your Lordship. Handing over of the land, they have replied, Your Lordship, 26 February 1980, from whom possession was taken.
Was any acquisition proceeding initiated?
It was allowed to lapse by government. Then under the new act also it was allowed because of, we don't know exactly, but ultimately it was done in 2021 under emergency clause section 40 of the new acts, Your Lordship.
Lord, on aspect, sorry to interject, my Lord. This respondent number 3 is also a necessary party.
No, he has been saying respondent number 3 has been struck off.
Struck out, yeah, has been struck out because, Your Lordship, from their end it is completed. struck out because they have paid compensation.
By order dated 5/7/2022.
Yeah, it was struck out because they have paid compensation, and the compensation amount is still lying with the deputy
So now,
commissioner. Your Lord.
so what is your case, Mr. Sawa?
My case is
your land was taken over
by BSF.
purpose of by BSF.
Yes.
For the construction purpose of construction of the outpost.
Yes, Your
And
Lordship.
the compensation
Already paid.
Paid by the
BSF.
BSF to the government.
To the district collector.
Collector.
And that amount is laying there.
Amount
it
is
is
lying
pending with district collector. Since they have not paid, my case is that limited case that they should release that amount to the landowner, to the petitioner.
Yes, Mr. What is the it's a simple case?
No, my lord. The stand which is taken by the government, my lord. Now, there is a claim and counterclaim, my lord. There is another party, and we have, in very detail, we have stated in our affidavit.
If if there are other parties,
till the time, yes, my lord. Of course.
That counterclaim.
She is not made a party here.
Yeah, she should have been made a party, Mr.
Your Lordship, because when we are filing this one, the petitioner was not aware of this counterclaim because the land has been settled. Even counterclaim was in the case of Nogmasip, Your Lordship. Nogmasip.
No, there was even objection, my lord.
But
there was also objection to the award. The her name Shrimati Filoni Armara. So that person had also filed an objection, my lord, before the office of the deputy.
Have you stated that in your
yes,
counter?
We have in a very detailed way.
Then have you filed your rejoinder to that?
We are yet to file rejoinder, Your Lordship, but this Filoni Mara, her petition, it went to the High Court twice, Your Lordship. The first he has got from the then PK Sangma CAM that some part of their land is belong to Filoni Mara, but that is obtained by through manufacture. So and it was done without the knowledge of the real Nagme di Sangma. So the Honorable High Court in 27/5/2013 has struck down that one, and they have referred back to the District Council, Your Lordship. Then when the District Council was examining the matter, it was they have come again. Filoni Mara has come to the High Court. Then on 26/18/2016, by this order, this Honorable High Court has rejected their petition, and they have directed that District Council should go by the record, available in the District Council when deciding this Nogmasip.
So that is with regard to the
Nogmasip.
Claim of Filoni, you said.
Yes, claim by Nogmasip. Then later on, Your Lordship.
If she could sustain that claim, then she would have been entitled to this.
Yeah, she will not be, because this land belong to the Nogme, Your Lordship.
So her case has been decided. It has been decided against her.
Yeah, has been rejected now in by order of this EM on 28/12/2017. They have struck down. They have now they have given the ownership of Nogmasip to Nogme only, Your Lordship, and also the EM also on 12/10/2018 upheld that order of EM. So two concurrent court.
But is that order conveyed to the? Was it conveyed to the collector?
Yes, Your Lordship, it was conveyed, and we can see from their affidavit in opposition only, Your Lordship, page 70 to 79 in their affidavit in opposition. And also CM order on page 85, 86.
Yes, sir.
Very long order, Your Lordship.
This is, you're referring to page
72, 79, Your Lordship.
72 is
72 that on
that's
the
the order.
corner is not that, sir. Corner is wrong. That in the corner, that in the middle, Your Lordship.
What is wrong?
An EM order can be seen at CR 85, 86. Your Lordship. CM. Now, Your Lordship, they have challenged this order before this honorable High Court, but it is in different bench, Your Lordship. But even this thing, but this particular plot of land is the belong to Nagme only, Your Lordship, and it is covered by Pata, already covered by Pata.
Because you will
Nogmasip is belong to the clan, to the clan. But this very plot of land, where this under this petition now, it is belong to her, Your Lordship. It is issued by the Pata, covered by Pata, issued by the private property, Your Lordship. So it does not have any impact with that other writ petition, Your Lordship.
No, we are not looking to that. The only thing is that, as far as this case is concerned, you are saying that this land is your private property.
Yes, Your Lordship.
And the government would say that there is also a counterclaim by some other person, particularly that.
And they don't have, the other party, they don't have document, Your Lordship.
My lord, this fact was pointed out. My lord, this order is under challenge before this honorable court.
What order?
My lord, the order dated.
I have said just now, Your Lordship, that is under challenge there.
That order by the CEM?
CEM and EM.
But how would that affect the facts of this case?
It has no relevance with this case, Your Lordship.
Because I think this is with regard to ownership.
Yes.
So, my lord kindly goes to the affidavit, my lord. Here we have stated that the objection is also filed by Piloni Mara. It is in, my lord kindly refers to para 5. Otherwise, I could have considered, my lord. But this is the stand which is taken by the state. Para 5 of my affidavit, which is at page 3, my lord.
Yes.
If I am allowed to read.
Yes.
That in response to the averments made in para 3 and 4 of the writ petition, the answering deponent states that the dispute had arisen in regards to the Nokmaship and more particularly for the Aking land of the Chandobi. That is that area, my lord.
Yes.
Where the land was taken, which land is acquired for establishing a border outpost between the petitioner and one Srimati Filoni Armara, who claims to be the Nokma or landowner of Chandobi, being the Nokka of Haduk Chol Aking land, which the petitioner has suppressed in her petition before the Honorable Court. And in this regards, both the parties have been submitted. My lord, this error is very clear.
This
Both the parties have been submitting representations after representations to stop payment. So, my lord, it is not that one party is. My lord, both the parties have filed representation to stop payments against each other. Stop payment as well as to release in many occasions, but till date no final judgment or order has been submitted by either party to show that she is Nokma of the said acquired land of Chandobi. As far as handing over a portion of land at Chandobi to the BSF for establishing a border outpost is concerned, the deponent has no comments. So, my lord, this para itself, my lord.
This writ petition, your lordship, this affidavit in opposition, your lordship, it is completely not according to the case. It is like supporting the...
Mr. Sangwal,
yes,
this court at the outset has inquired from you when a counter affidavit is filed or affidavit in opposition is filed. It is incumbent upon you to, if you dispute the contents of the same, to file a rejoinder. But you said no rejoinder has been filed.
Till now we have not filed, your lordship.
If no rejoinder has been filed, then the amendment has to be taken as facts. Because here you see, as Mr. Sarji has pointed out, in paragraph 5, it shows that there is a dispute over the ownership of the land.
If I am allowed to read para 6 also. So that is why otherwise I could have not considered. But the point here is, my lord, I have to go by what is stated in the affidavit. That in response to the averments made in para 5, 6 and 7 of the writ petition, the answering deponent states that on receipt of the application, representation dated 25/7/2003, filed by the petitioner, the process of land acquisition was initiated under Old Act of Land Acquisition Act 1894, and preliminary notification under Section 4 of the Act of 1894 was sent to the Under Secretary of the Government of Meghalaya, so and so, dated 10th August 2011. But whilst waiting for approval, a complaint was received from Srimati Filoni Armara.
Your lordship, I think,
dated 10th October 2011, claiming to be Nokma of...
Anyway, see, what is understood is a proceeding. You see, I think this was under the old act then.
Under old act, yourself.
So, if under the old act, then you have to first go by section 4.
Yeah, that has
section,
been left, your
section,
lordship,
then section 6.
from their counter affidavit.
Thereafter,
under the new act.
Government wanted to proceed in the new act, my lord, but the petitioner insisted that it should be under the old act.
No, that has been lapse, both have been allowed to lapse. Now they have gone under emergency clause section 40.
Even then, they may have. But what under the new act? What is the provision which is para materia to section 30 of the old act?
The new act is right to fair compensation, which is
fair compensation.
Because under section 30, if there is a claim and counterclaim, then the court has to decide. Matter has to proceed before the land acquisition special court.
Your lordship, this thing has been completed, and they have written to the BSF to release the fund. So they have released. That is the thing, and they have gone under section 40.
As far as the BSF is concerned, I think that part is clear. They have taken possession of the land. They
yes,
have
money also paid.
Erected a check post.
The fund is
and the fund is lying with the collector.
Lying with district collector.
Now it is for the collector to decide.
To release only.
To decide.
Yeah.
Whom to give the money to.
Exactly.
Now,
and
if there is a dispute. As to the award. Or claim over the award, then the Land Acquisition Act has to be followed.
Yeah.
In the old act, like I said, we have section 30.
Yeah.
But in the new act, I don't know what is it.
As far as inquiry is concerned, it is in section 23, my lord. Inquiry and land acquisition award by collector. Then, my lord, section 24,
Yes, ma'am.
Please, my lord.
That felony is claimed non-massive, and in fact, Your Lordship.
No, my lord, the question is.
We will not go into that. First,
Yeah.
first we look at the procedure.
Yeah.
What is required to be followed?
Lord, I understand what my senior is submitting, my lord. But here difficulty is that had there been no complaint before district collector, it would have been absolutely fine. But because there is complaint.
Exactly. So how is that to be dealt with under the relevant acts? We are going by the new act, isn't it? You said section 23 of the new act.
My lord, we had made a submission. My lord, kindly bear with me.
If we go to the page 91, Your Lordship, of the affidavit in opposition.
My lord, if I am allowed to read, continue reading para 6, but I'll take my, if I am allowed to take my lord to page 5, my lord.
Yes.
My lord, I'll start from the second para, my lord. I'll start from the beginning, my lord. In the meantime, an amount of rupees 19 lakhs, rupees 80 so and so was even received from the requiring body. White letter dated 30 March 2012. The dispute between the petitioner and Srimati Filoni R. Mara kept on hampering the land acquisition process. Then, white letter dated 27 March 2013, Srimati Filoni R. Mara submitted the final judgment and order passed by CEM, GHDC, and the petitioner as well as have submitted a petition representation dated 5/4/2013, informing that they have preferred an appeal before the Honorable High Court of Shillong against the order dated 15/3/2013 passed by the CEM and requested to stop payment of compensation until final adjudication. During the pendency of their dispute, the land acquisition under the old act got lapsed, and therefore the answering deponent has initiated the land acquisition afresh under the new, that is, my lord, Right to Fair Compensation and Transparency in Land Acquisition Rehabilitation Act 2013, and for the same consent was obtained from the Secretary Executive Committee dated 18 September 2015 and the Deputy Secretary to the Government of Meghalaya Revenue and Disaster Management Department was pleased to exempt the SIA study dated, so that is 2nd June 2015, and thereafter the preliminary notification under section 11. So that preliminary notification was again issued under section 11 of the new act was to Shillong White dated so and so for approval, and the same got approved under
Section 4
of the new act, White RDA dated 5th July 2017. What does section 4 mean? Section 4 speaks about preparation of social impact assessment.
Yes, you reading?
Petitioner has submitted the petition. If I am allowed to, my lord, the
Yes.
petitioner has submitted the petition representation dated 24/1/2018 for release of payment of compensation and have enclosed the order dated 28/12/2017 passed by executive member GHDC, and again the petitioner submitted a petition application dated 5/5/2018 for release of the compensation as per the old rate. My lord will kindly see it's mentioned here. And act. Accordingly, the remaining process of land acquisition was proceeded as per the new act, and the SIA study report was submitted wide letter dated 26 November 2018 by the officer on special duty, Meghalaya Institute of Governance, Shillong. Then, in the midst of proceeding with land acquisition as per act, the petitioner again submitted a petition dated, application dated 24/6/2019 for release of compensation and enclosed the judgment order dated 12/10/2018 passed by the CEM GHDC. The answering deponent proceeded with the land acquisition thereby has sent a preliminary notification under section 11 so and so dated to the 12th March 2020, and accordingly proposal for initiation of section 40 was sent to the Revenue Department in Shillong, right letter dated 13 July 2020, and the same got approved right dated 2nd March 2021,
and thereafter notice was issued to the represented respective NOCMAs to conduct hearing under section 21. So that was what I was referring to, of the new act. But in the midst of process of land acquisition, the answering deponent has received a legal notice dated nil from so-and-so advocate, High Court of Meghalaya, on behalf of client Srimati Filoni Armarak in respect of payment of compensation for construction of the border outpost, and also received a reply from so-and-so advocate, High Court of Meghalaya, white legal notice dated 30th April 2021. Further, the answering deponent has even received a legal notice dated 11 May 2021 from so-and-so High Court of Meghalaya, alleging that no action has been taken from the office of answering deponent for payment of compensation of the petition. So, my lord, again here also, my lord, two parties have sent their legal notices.
From here only, your lordship, it is seen that the order of EM and CM already furnished to the DC.
Then in the midst of,
but they have not taken cognizance of that one.
In the midst of unsettled dispute.
In fact, in that order of EM and this thing, the NOCMAship has been settled in favor of the petitioner, your lordship. Now, two court concurrent views and has been given. It become a finality, your lordship.
If I'm allowed to read further.
And not only that, your lordship, this plot of land where now the BSF has taken is belong to her only. It is covered by Pata or Sosa. Not only clan land, it is a Pata, private land, or it is, your lordship.
My lord will kindly see this para, if I'm allowed.
This is all what they have filed here, a opposition, is not according to the fact, your lordship.
My lord, I have to go by what is stated. This is filed by...
The record is speak differently.
My lord, if I'm
they
allowed
have,
to read.
They have filed on the basis of the representation by the third party. Mainly based on the petition of the third party, not looking to the actual fact. She is also the NOCMA, and also this plot of land is the ownership owned by her.
No, but all those, you see, that has to be clarified. That has to be clarified by you.
Yes,
if there's a third party claim or the, then you have to clarify your position.
Yes, you know.
But the fact remains that you have not filed any rejoinder.
Yes.
Now
I'll check from record, your lordship. I think on 4th this thing, September, I have filed this. I have a copy, but I don't know. I will check from the registry, your lordship.
If it is here, it should be.
My lord, only if this para if I'm allowed to read, my lord. But I understand, completely understand what is happening. If I'm only allowed to read this para, my lord,
yes.
Thereafter I will not proceed. Then in the midst of unsettled disputes between the petitioners, Srimati and Srimati Filoni Armara, a bank draft of remaining amount of 62,88,426 as per the new act and rate of payment of compensation was received from the construction officer, that is from the BSF. But yet again, Srimati Filoni Armara filed a complaint dated, so these are fresh, my lord. It's not that these are old complaints. Filed a complaint petition dated 7/3/2022 to stop the payment of compensation and until final adjudication of pending High Court case WBC number 393 of 2018.
That is in another bench, your lordship.
Clearly stated in this paragraph, my lord. Otherwise, I would have considered. Hence, it is not understood as to how petitioner is expecting the state respondents to take action on part of answering deponent without ascertaining the actual land. That is the difficulty.
When there are disputed questions of facts, I think the matter has to be taken up by the appropriate authority, more likely the civil court or the special judicial officer in land acquisition. Otherwise, in a writ, I don't think it's possible. Now what has emerged is the fact that you, as far as your assertion is concerned, you may have a very good, you may have very good title.
Exactly.
You may have very good ground for claim. But if there is a counterclaim, that has to be addressed. That has to be addressed. It has to be decided by a proper forum. And once that, as far as this matter is concerned, once that forum is, decides whether it is a civil court or CEM or whatever the case may be, or confirmed by this court, then it will be clear. Then this court can decide or can allow your, your prayer. Otherwise, at this point of time, I think I don't think it'll be possible for this court to decide.
According to Garo Hills Autonomous Custom Uses Act, the District Council EM and CM has decided no other court has jurisdiction to decide on Nokmasip, Your Lordship. A civil court has no jurisdiction.
Yes, civil court has got, but you see, that is why parties.
And this
that is why parties have come.
In this case, already decided by the.
But as you see, Mr. Sama, you know very. I mean, you know very well by now.
Yes.
That in such a situation, parties usually approach the High Court under 226.
Yeah.
So the High Court will look into will take a call as far as the propriety or impropriety is concerned.
Yes.
So that is, to a limited extent, is there. But here, as it is not clear. The picture is not clear.
Yes.
On top of the fact that in course of proceeding, when as soon as the counter affidavit has been filed, you could have made a prayer for impleadment of
Exactly.
the other person.
Then it would have been.
Then it would have been clear. Then we could have got a response from her.
Otherwise, my lord, if there is a question of title, etc., over a land, I'm not going into the Nokmasip matter. My lord, that also is, matter can be referred to special court also on that issue.
Yes, this is good.
Your Lordship.
You see, nobody is depriving you of your rights.
Yes.
The only thing is that it has to be done properly.
Yes.
Either it is as far as this court is concerned, I think this is not a proper forum.
Then kindly allow me to file a rejoinder, Your Lordship.
Sorry, first to check the record whether.
I will check the record. Then
No,
if not,
rejoinder is already here.
already there.
4th September 2023.
Yes. 4th September. Yeah.
We are not talking about rejoinder here. We are talking about, well, we'll look also into the rejoinder.
Yes.
But we are talking about the impleadment of proper and necessary party.
That can be done.
Yes.
So you get your instruction.
Yes.
Get your instruction, and we'll see.
Yes, Your Lordship.
This is matter of 2 weeks then.
Okay, 4 weeks.
Otherwise, my lord.
2 weeks or 4 weeks.
That case is coming on the 16th, Your Lordship.
I don't know how, whether that whatever
has no relevance because this is a normal.
That order was challenged.
Yeah, that is that
challenging
order of
that EM and CM only, Your Lordship.
That is only with regard to Nokmasip.
Nokmasip, yeah.
But
my lord, this
regarding
is
plot
also
of land,
claiming the ownership in that same area where the petitioner is claiming.
But now no, they are according to the CM and EM, Your Lordship. She is no more the Nokma.
No, that is okay. That is okay.
No
but
more.
now this court will have to decide on that.
Yes.
Whether the decision taken by the EM and the CM is proper or not.
Yes.
Then eventually,
yeah.
See what happened is eventually, if we are not saying anything here, but if the court decides in favor of that petitioner, or Filoni, is it?
Yeah.
That's her name.
Yes,
if it decides in her
Filoni
favor, then what happens is, then she will have a claim over this land.
Yeah.
And you will also have to defend your title.
Defend, yeah.
So,
and then this land covered by Bata in favor of the petitioner. That also.
Otherwise, my lord, district collector is ready to disburse the money.
No, we are not saying the money is there with you.
Money is there.
As far as you are concerned, you are just the custodian of the award.
Even the enhanced rate is with us.
Okay, 4 weeks then.
Yes, Your Lord.
Mr. L.M. Sawal, and a counsel for the petitioner, has sought some time to seek further instructions from the petitioner as to how this matter is to be proceeded before this court. On permit, the same is allowed. This is matter up to 4 weeks.
Highly obliged, Your Lordship.
Item number 9.
Paul is still on legs, my lord. Otherwise, my lord, this matter has already been heard, my lord. This is regarding that this is a review petition, my lord.
Exactly.
Only on the ground of fraud, my lord. The appointment order of the.
They have been heard, but you have to.
My lord.
I don't know whether the matter has been heard or not. Why is it coming from time to time? It has not been. That means hearing is not completed.
They are raising some other question, not going to the reality of the review petition. It has been heard number of times.
So that is the problem. You see, that is the problem when a matter has been heard number of times and it keep being adjourned. Keep being adjourned, and that is why I see it would have been better for parties to take up the matter and get it heard once and for all. Otherwise, if we hear piecemeal, so it will not do anything.
The crux of the matter here, my lord, there is a, my lord, there is a very simple issue, my lord. Both of them are claiming that their appointment is genuine and their certificates are genuine, my lord. This honorable court won't be able to determine that, my lord.
Yes, of course. If there are disputed questions of facts,
my lord, yes,
the court will not go into it.
That is the exact issue here, my lord.
But the point is, on that issue, whether it is whether this it has been reflected in the impugn order or not, that is to be seen.
My lord.
For an application of review to be considered, because review is is very limited. The scope of review is very limited.
Very limited.
But if there are good grounds for review on issues of facts and matters of record, then
in the review petition, my lord, the allegation is that certain facts were not brought before this honorable court at the time of passing the order in the first round of litigation, my lord. That is the issue here. Very limited.
What question they have raised is already in the petition.
But Mr. Jarika, if I recall, I have vaguely just recall that there was also an issue of forgery of
exactly, ma'am.
Of the
appointment order of the petitioner.
Subsequently, it was found. So both the parties produced documents.
Yes, if that is the case, then
it is not found, my lord. It is already there in the previous writ petition, my lord.
My lord.
If it is new discovery also, that is another question.
Okay.
It was there.
Or it was there.
Yes.
That the issue of forgery is there.
Yes. No.
No.
No, my lord, that issue is not there, my lord. On bare perusal of that appointment order, my lord, it can be seen, my lord, it is forged and fabricated, my lord.
No, my lord.
That is why, you see, that is why you cannot say this and I cannot say this.
Yes,
because these are all matters of forensic examination.
Yes,
so who is to decide? This court cannot decide on that.
Cannot decide.
And moreover, they are continuous for 17 years in the service, both of them.
That's the difference.
Question does not arise from the committee.
No, that is the difference.
Suddenly they are raising, after raising also, they are not agreed to send this forensic effect might have been long time back. They are making another allegation than this one, but reality they are not going. And as per section 47, new discovery cannot come into this play.
Whatever the case may be,
yes.
The High Court, in a writ.
No, anyway, my lord, this case would be closed down, my lord.
So far, state is concerned, my lord, the limited role of the state is for, my lord, approval. And my lord, the termination of the respondent here was never brought to my notice, my lord.
Yes, it is not there.
So we'll hear the matter, Miss.
My lord, may then fix it tomorrow, my lord. Can be closed down.
Yes, this has been lingering on for so long. Case, no? on pre-made by the parties. Let's this matter tomorrow.
My lord.